Chapter 37 Miscellaneous Section 474 to 484. Under which one of the following section of CRPC trial of the case can be taken before High Court? Section 474. Where a judge or a magistrate is personal interest in the case, he shall neither try to commit nor try such case, not prevail her any appeal in case provided prior permission of the appellate court has been obtained. Which one of the following section of CRPC 1973 provides that no judge or magistrate shall try any case in which he is personally interested? 479. Inherent power of under section 482 of CRPC exercised by High Court only. Under section 482, inherent power is exercised by High Court. Under which section of CRPC inherent power can be exercised by High Court? 482. Which section of CRPC deals with inherent power of the High Court? 482. The accused mentioned in FIR want to request he would approach the following court, only High Court. Inherent power under section 482 of CRPC can be exercised by High Court only. Section 484 of CRPC deal with inherent power of the High Court, in which case Supreme Court of India directed High Court to exercise jurisdiction under section 482 of CRPC, State of Haryana versus Bhajan Lal. While exercising the inherent power under section 482 CRPC, the High Court cannot do all the mentioned thing. Under section 482 of CRPC, High Court exercised inherent power. The High Court, under its inherent power conferred under 482 of CRPC, passed the following order. It quashes the FIR. It quashes the proceeding of the case pending before the criminal court. It expugns the derogatory remark against the member of subordinated court. Inherent power under section 482 of CRPC can be exercised by High Court. Under which section of CRPC High Court has inherent power? 482. Which court can exercise inherent power in the criminal cases? High Court. Under section 482 CRPC, joint trial can be splitted up. 482. Prisoner released before the punishment complete is called parole. Not correctly matched. Summary dismissal 384 of CRPC. In the case of Dina versus Union of India is related to hanging, any mode of execution. Not correctly matched. D. Police to prevent cognizable offence 149. Power to arrest the prevention and combination of cognizable offence 151. Power to certain armed forces officer dispense assembly 131 is correctly matched. Information in cognizable offence 154 not correctly matched. Reason for applicability of some of the provisions of CRPC of the state of Nagaland has been stated by Supreme Court in the case of Zarzulina versus Government of Mizoram. Cognizance means arrest and investigation without warrant of state. Mark the incorrect statement. D. Match joinder of charges. Section 218. Examination of the complainant. 200. Cognizance of offence by magistrate. 190. Order of maintenance child and wife. 125. Anticipatory bail not correctly matched. Anticipatory bail 438. Summary dismissal 384. Reference to High Court 394. Compounding an offence 320. Delay in examination of witness by investigating officer does not ipso facto make the prosecution vision suspect. Investigating officer should categorically question the aspect and delay examination was held in which one of the following cases. State of UP versus Satish. In which one of the following cases has been held that presence of law at a time of interrogation cannot be demanded as a matter of right. Pulpandi and other versus Superintendent of Central Excise. Senior Intelligence Officer versus Jugal Kishore Sharma. Who write the evidence in a criminal trial? Magistrate. Classification of summon case and warrant case. Help in determining the trial. The procedure to be adopted helps in decide the question of issuance of process to accused. Examination of person accused of rape by medical practitioner and inserted by CRPC amendment of 2005. Any dispute relating to the possession of immovable property under CRPC is decided by executive magistrate. Which one of the following combination is correctly matched? Ordinarily, second stage of criminal case inquiry. It is not a judicial proceeding. Investigation. Summary dismissal of appeal 384. Anticipatory bail 438. Abatement of appeals 394. Compounding offence 320. Which Supreme Court case decision is related to narco analysis from among the following decided case? Selvi versus State of Karnataka. The direction to ensure the police officer do not arrest accused unnecessary and magistrate do not authorize detention casually were issued by Supreme Court in the following case. Arnish Kumar versus State of Bihar. In which one of the following case Supreme Court held that the law does not mandate taking to the prior permission for further investigation or carrying out the further investigation even after filling the charge sheet. It became a statutory right of police. State of UP versus A.S. Peter. The summon cases and inquiry memorandum is the only record of witness. In which one of the following case the Supreme Court recently directed to upload online copy of FIR within 24 hours of the lodging? Youth Bar Association of India versus Union of India. Maximum period for which under trial can be determined not more than half of the maximum period of the punishment for the said offence. The Code of Criminal Procedure amended by Parliament or any state legislature. The main characteristic of the new Code of Civil Procedure is separates the judiciary from the executive. Under Criminal Procedure Code 1973, a magistrate can commit a case to Court of Session, which is not exclusively triable by Court of Session, if it appears to him that the case is such that the case is one which ought to be tried by Court of Session. The main characteristic of Code of Similar Procedure 1973 is separation of judiciary from executive. The purpose of criminal law is preventive crime. In certain situations, private person can arrest another person. Consider the following statement. The word in the section 145 is discretionary. The proceeding under section 107 can be converted into 145. Which one of the following statement is not correct under CRPC? Complaint may be made to any person and it is not necessary to injured inquiry to affected only should be complainant. Which one of the following is not correctly matched? D. Conditional order for removal of nuisance 133, procedure where extension of public right denial 137, dispute concerning right to use of land and 147. CRPC Amendment Act 2005 received assent of President on 23rd July 2005. Which one of the following case it has been laid down by Supreme Court that where the version of complaint case and the police report is totally different and contradictory, such case should be tried separately by Suresh Chandra Jain versus State of MP. A, who undergo detention during trial, has been sentenced to pay a fine of 1000 rupees and suffer a simple imprisonment for a month default of payment of fine. A failed to deposit the amount of fine and made to undergo imprisonment for default. A claims set off. In the situation A, not entitled to set off. The distinction between the police investigation order under section 156(3) and one directed under section 202 has been clearly brought up by Supreme Court in the case of Devarpalli Lakshmi Narayan Reddy versus N. Narayana Reddy. A magistrate can issue summons to the accused appear before the police officer. The statement is false. One of the non-completion investigation, the failure of prosecution to file a charge sheet within the prescribed period of 90 to 60 days is the accused person shall release on the bail if he is prepared and does not furnish bail. First schedule. The classification of offence of believable and non-believable has been given in the CRPC under section first schedule. Classification of believable and non-believable offence under CRPC provided in first schedule. What offences per label? Mentioned in the label in first schedule of CRPC. List of cognizable and non-cognizable is provided in schedule first of CRPC. Believable offence means offence which is shown believable in first schedule of CRPC. Believable offence means offence which is shown believable in the first schedule of CRPC. Under the scheme of CRPC, offense has been classified into billable and non-billable, cognizable and non-cognizable. First schedule. Second schedule. Which provision of the Code of Criminal Procedure 1973 prescribed the mode of execution of sentence of death? The convicted by hanging by neck until the death is form number 42 of second schedule. Supreme Court of India has recognized the presumption of innocence as a statutory right, in which case it was held that at the time of framing of charge and taking cognizance of the accused has no right to produce any material. State of Odisha versus Devendra Nath Padhi. In which one of the following cases it was held that accused cannot be use the diary. Neither the accused nor the counsel can. Restitution of case diary has been. They cannot be claimed to go through it. Mukundlal versus Union of India. Code of Criminal Procedure divided into 37 chapter and 484 section. Form number 32 of second schedule of CRPC provide the format for forming of charge. Offences against other law except IPC, if punishable with imprisonment for term 3 years and upward but not than 7 years, then it will be cognizable and non-billable.